we can see what happens. And I'm going to start, oh, the recording started automatically, so perfect. Hi, everyone. We're going to give it just one more minute before we go ahead and start. Thank you for joining us for this event. Okay, good afternoon, everyone. We're going to go ahead and get started now. Long Day, I'm going to ask you to stop sharing your screen. Welcome to today's event on business and human rights in the context of Ukraine. My name is Tara Van Ho. I am a senior lecturer here at the University of Essex School of Law and Human Rights Center, and one of the co-directors of the Essex Business and Human Rights Project. We're coming to you today to talk about the connections between what's happening in Ukraine and broader connections, lessons learned that we have from other contexts, and lessons that we need to be taking forward from Ukraine. Before we get started, I do want to address the fact that we do not have a Ukrainian speaker on this event. I have been publicly quite vocal about the need to make sure that Ukrainians are at the forefront of this conversation. This is the second of two events. The last one focused very specifically on what was going on in Ukraine. And there comes a point within our field, as many of you will know, we have very few, numerically few Ukrainian business and human rights experts. And there comes a point in which we have to think about, as a field and as individuals, what we ask of those experts and when we ask them to speak. And I think they are doing so much work right now around the broader issues regarding business and human rights in Ukraine. I wanna single out here Elena Uvarova, who is a powerhouse within the field of business and human rights generally, but who has been asked to lead a lot on issues and conversations around Ukraine. And I think there comes a point where the rest of us have an ethical responsibility to take the conversation and to be selective about when we ask and put the burden on leading on this conversation on them. And so Elena was a part of our past conversation on business and human rights in Ukraine. If she's present today, she can always ask to intervene and I will always give her the floor. But that's why we're now looking at it from a lessons learned from other experiences. And so we're centering other voices on this in the hopes of both buttressing our friends who are from Ukraine and also ensuring that we don't ask too much of them in this time. The other thing I want to note is that the UN Working Group on Business and Human Rights does have a report out already on business and human rights in situations of armed conflict. If you're not familiar with that, I would encourage you to look at it. They will have another report out next month on the relationship between business and human rights in transitional justice. So the post-conflict reconstruction periods of truth and justice. And so that will be coming out next month. So keep your eyes out for that. The final thing I want to say before we get started is that we do have a significant amount of time for questions and answers. So please do use the Q&A function. Please don't use the chat function. We will not have enough time. I don't have the ability to manage both things. So we're really going to focus on what's in the Q&A portion and not what's in the chat portion. With that, I should note that we believe in freedom of speech, but we do not believe in abusive actions in these conversations. If there is an abusive comment, if there is abusive action, and that includes towards any of our speakers individually or collectively, my student worker, Longdi, has full discretion to kick you out of the room, and she will do so, and I will have no apologies for that. So please keep all of your comments, questions, criticisms collegial and appropriate. So I do see that Olena is here. And Olena, I will, at the end of the event, if there's anything you want to say, you're always welcome. So with that, let me introduce the speakers that we do have with us today. I'm going to start with Celia Chipothe, who was formerly with Amnesty International, and he's now a senior advisor at the Institute for Human Rights in Business. Celia is one of the forerunners, if I can say it in that way, of the business and human rights movement, and has been working on business and human rights and armed conflict for, am I allowed to say decades, Celia?
Yeah, about quarter century, something like that. Yeah.
Okay, somehow that made it sound worse, even though we were both saying more or less the same thing. But yeah, decades.
I'm old, I wear the bottoms of my trousers rolled, as Elliot said. So yeah.
Fantastic. We also have Avery Kelly, who's a staff attorney with the Corporate Accountability Lab based in the United States, but their work takes them all over the world. Corporate Accountability Lab was one of the conveners of the CLASP Lab, which is Corporate Liability and Sustainable Peace. It is a collective of NGOs and a few academics, NGOs primarily, who are working on issues of business and human rights in conflict and post-conflict societies around the world. And so Avery was brought into today's conversation to really bring that sort of global lens and lessons learned through the CLASP Lab. Finally, we have Dr. Shahad Hamari, who is coming to us from Cairo today, but she is normally based here in the UK with us, just around the corner, meaning a couple of hours away, but around the corner from us at Kent Law School, where she is a lecturer. She's also an expert on corporate accountability and the war economy. So thank you to the three of you for joining us. Shahad, I'm going to come straight back to you because your expertise really, while it also has the same global focus that both Avery and Celia bring to the conversation, you also have a particular background in working on issues of Palestine. And Palestine, of course, is, I think, primarily the closest analogy to what we're seeing within Ukraine because of the long-term occupation coupled with intermittent conflicts. And I'm using that in its legal definition. So for those of you who don't have a law background in international humanitarian law, this is not your fault, this is our fault. But armed conflicts, we often think of them as being synonymous with war, but they can actually, you can have an armed conflict that spans 10 years, or you can have a series of armed conflicts that break out in the same space involving the same actors with sort of breaks in between them. And so within Israel and Palestine and within Ukraine, you are seeing a combination of occupation, which always carries with it the laws of war for interstate war, coupled with sporadic armed conflicts. So that was a very lengthy explanation. And so for what is ultimately a simple question to Shahad, which is, can you talk about the experience that we have with Palestine, and what lessons are we seeing from Ukraine for Palestine, and what lessons do we have from Palestine for Ukraine?
Sorry. First of all, I apologize for joining in from my phone. Being in Cairo means generally having not control over everything. Currently in Ain Shams University. So let's, and thank you for the introduction. Exactly. There is a very big difference between any armed conflict and occupation. Occupation gives us this very specific supposed temporality, even though we've seen the historical recurrence of prolonged occupation. And at the same time, it's a much more defined space. So it actually, the growth of a war economy happens through different dynamics, because then you're looking into something that spreads over more time and within very specific space. So you can actually look at long-term investments, and that means that your involvement would be, let's say, much more nuanced, and actually it can vary in its levels of complicity. So let me just start with a very simple differentiation of how do we even understand corporate involvement in these contexts? Because usually when I say a corporate involvement in war or in the war economy, the first things that would cross our minds would be the arms industry and the private military contracting industries, who have a direct role in the facilitation of violence. Meanwhile, a lot of other industries that we don't usually think about could be indirectly involved in terms of banks, in terms of telecommunication corporations, and all of that. So in the context of Ukraine, actually, we saw a lot of corporations who are indirectly involved within the Russian economy decide to divest. So here, this generally, let's say, opens up a lot of questions in how was business and human rights understood in this context, which is something I'm going to be talking about a bit shortly. But let me just start with how business and human rights has been seen in Palestine for a while, and then I'll go to what how do we understand the discourse through the after we look at Ukraine. So in Palestine in general, the looking at corporate involvement has been something that has been called for by the local community for a very long time, and calls for accountability and calls for divestment, as inspired by the prior South African discourse, have been there since the 70s and the 60s. But it's been a very recent attention to the matter, specifically within the movements with the Office of the Human Rights Commissioner, when they decided to look at corporations that are involved in Israeli settlements and publish a database of corporations involved there. That exercise, despite it being very late in the eyes of the Palestinian civil community, actually gave the business and human rights discourse a new outlook in how do we understand the war economies. And actually, it's a very rare example of a contemporary piece of let's say that has some level of normative value, that was talking specifically about indirect forms of involvement. And my favorite word, which is a word that you find all around the discourse, but somehow, notions that you find all around the discourse, but not always solidified, is contributing to and benefiting from a given violation of international law. And in that piece, you actually, which was in, if I recall correctly, 2017 or 18, the first piece by the Office of the Human Rights Commissioner, they outlined specifically how is that understood in a context where settlements have been built ever since 70s, 80s, and investments have been rising, and for a good part of the time, investors look at this as just another investment and another space for which to partake in normal commercial activity. And we still have that, and it was a time where also the general feeling that, well, this is just commercial activity, it is very much disconnected from the politics of the place, and something like settlements was still considered to be a political question rather than actually a legal question and a legal obligation. So the report actually gave us a very interesting outlook, where how we understand corporate due diligence in the context of war actually changed a bit, because usually when we think about due diligence, we're thinking about avoiding a direct violation of international law. But how do we understand that substantively in the war economy is actually a very complex thing, because at the end of the day, even though they were not called upon to be saying that they were directly violating international law, but a lot of corporations who were, for example, benefiting from laws that were inherently discriminatory against Palestinians were called out in the report, or corporations that are benefiting from infrastructure, telecommunication, and at the same time who are economically contributing. So even by opening up a burger shop, you are economically contributing to the settlements expansion, and thus you should be called upon. So I think in general, when we look at the context of war, it distills, and it's a really big point of tension, let's say, where the corporation's personality as exclusively a private person is put into a question. And the reality of its effect on public considerations really rises up to the surface, and corporations need to or start to kind of get involved in things that affect public considerations, whether or not they like it. And actually, it's a very big point of critique for the business and human rights discourse and it has been a recurring point, specifically in the recommendations for the working group on business and human rights in relation to conflict affected areas, which is a place where we need to look at corporate autonomy much more, and we need to actually have a more nuanced understanding between the corporation's duty to respect and also a little bit of the corporation's duty to protect. Which brings me again to the Ukrainian context, where we saw this exodus of divestment, over 1,000 corporations thus far, and Yale University actually has this very big infographic of all the big names that divested. And the divestment in this case, the big divestment is from the Russian economy. So if we were to understand this in the business and human rights outlook, we are looking at not contributing to a war economy, not contributing to a state's economy that would eventually allow for the proliferation of war, which is actually this would be a very progressive outlook into the business and human rights discourse. But the thing to bring forth here is actually a critique that has been surfacing all the time around the business and human rights discourse, which is, whether or not we like it, international law is very much intertwined with politics. And by putting the main focus on the home state, specifically in conflict-affected areas, the business and human rights framework for conflict-affected areas, we end up allowing more space for the business and human rights discourse to be used in a functional light, more in line with foreign policy, rather than a space where the interest of the subject affected by the war economy is the most important thing. And let me just recap for those who are not very familiar with the business and human rights discourse. In the case of conflict affected areas, what happens is that the corporation has a heightened duty of due diligence, and that is to conduct due diligence and study into seeing how possibly it could be complicit in violations of human rights or violations of international law. But in this case, when we look at the directive in relation to this heightened duty of due diligence, we actually find that the weight shifts from the host state to the home state, and there is more weight on the home state to give directives to the corporations on how to function. But this also means that still, yet again, we are that the discourse is not acknowledging how far the corporate state symbiosis can affect the war economy. And in the case of Russia, you saw a huge influx that really responded to the liberal status quo in the sense of also feeding into the sanctions regime, which is a whole other topic. But in this case, there was a big question of, are we divesting to protect Ukrainians? Is this strategically thought of in a way where we can protect Ukrainians, or is it simply in response to this foreign policy agenda, and also to the legitimating power of corporations in the sense of them fearing for their reputational value? So in short, Ukraine showed us how it gave light, and it allowed the critique of the business and human rights to surface, in the sense that it's a functionalist reading that functions in some environments and not. And of course, the selective use of the selective use and practice of attention to corporate involvement in war was something that reverberated in a lot of other countries. Now you remember your duty towards human rights, but at the same time, this also affected people in Ukraine in the sense that there was an absence of strategy, in the sense that not all businesses have to respond in the same way, and as given in the example of South Africa, it's not the answer is not always to divest. Sometimes the answer is to function in different ways. Specifically, if we were to keep the interests of Russian and Ukrainian civilians there. And also, if we were to understand the different dynamics of, for example, how the banks industry works. So in short, and just to recap, I apologize if I've taken too much time. If we were to take a lesson from the Palestinian discourse to the Ukrainian discourse, is that at the end of the day, corporations should be really wary, not just of the substantive scope that is in compliance mechanisms, that is, I just want to avoid what could be understood as complicity in international law, because in international violations of international law, because these are evolving, and at the end of the day, you should be avoiding contributing to and benefiting from the overall economy that could feed into the proliferation of violence. That sounds difficult, but this is something that is needed to do to avoid complicity, and this is I'll expand on this further on. Meanwhile, what we can learn from Ukraine to Palestine is, one, the affirmation of a lot of the critique given to the business and human rights discourse, and also the affirmation of the need to protect against the functionalist treating of the framework, and for corporations to have more vigilance in understanding how, at the end of the day, when deciding what to do, the priority ought to be the subject affected by the war economy, regardless of who they are, and regardless of what could that mean in terms of profit sustenance. And thank you, Tara. If you have further questions, or I don't know how far did I take with the time.
No, that was perfect, Shahad. We're going to come back to you in a little bit. Anyways, I do want to highlight a few things that I took from Shahad. I've been a long time fan of hers. I don't think that I get to gush about her enough in public, but I'm a huge fan of hers, and now you all understand why I'm a huge fan of hers. So I took a bunch of notes, and I'm going to try to just highlight a few of the things that I thought were particularly important for us to keep in mind as we move forward in the conversation. The first is that we really need to start thinking about beyond the respect framework when we're talking about corporations within situations of armed conflict, and think about when is it that they need to be functioning with a protect. And I would even go further than Shahad in this and say, and a fulfill function as well. So respect traditionally under international law has been understood as avoiding causing harm, so avoiding interference in the realization of the right. The protect is when you stop others from interfering in the right, and the fulfill is when you take steps on a progressive basis to make sure that the right's enjoyment is enhanced. And traditionally, we've always said that businesses have, the guiding principles say businesses have a responsibility to respect, but we don't go further and say protect and fulfill. But the complexities of an armed conflict are such that sometimes businesses are actually being asked to do more than that. And I would, and hopefully we'll have time during the Q&A to talk about the arms trade and the arms industry and what it means for them to respect in a situation of armed conflict actually does transgress into a protect and fulfill. The other thing is that this exodus from the Russian economy, Shahad pointed out, seems to be a quite progressive interpretation of a business's responsibility for human rights, because what we're seeing there is an understanding that they need to leave so that they're not funneling money into the war economy, into an economy that would ultimately sustain or facilitate conflict. And that is a much more progressive interpretation than what we've seen. Shahad and I have been around the block on the Palestine issue for a couple of years. We're not at a quarter of a century yet, Celia, but we'll hopefully, inshallah, get there. Well, hopefully not on Palestine, but hopefully in the context of armed conflict, we'll be around for a while. But within that, that's a quite progressive interpretation. And if it takes hold, it actually has some really transformative effects or transformative possibilities. Unfortunately, of course, it has been used as a tool for politics, and we need to sort of see what it means to solidify that. But we are seeing this evolution in the understanding of complicity in international law. And so businesses need to be aware of that, and they need to be thinking about how are they doing that. And when they do that, they need to be thinking about the centrality of the rights holder. And that centrality of the rights holder is something that we talk a lot about in business and human rights. And it really needs to be something that comes to the fore of the legal analysis a lot more frequently. So with that, I'm going to turn to Celia. I'm also doing, sorry, the tech here. So yay, Celia. The Institute for Human Rights in Business has been doing a lot of work with Myanmar. You guys were some of the first people in on the ground when Myanmar opened up several years ago. It's now closed again in many ways. The Myanmar Center for Business and Human Rights was on the ground. I don't know if they're still on the ground, so maybe you can update us on that. But they were, at least for years, on the ground doing a lot of the work to try to help Myanmar's economy transition to something that was more respectful for human rights. So let me come to you and ask you the same question that I asked Shahad about Palestine, but in the context of Myanmar. What lessons should we be taking? What lessons should we be taking from Myanmar for Ukraine, and what lessons should we be taking from Ukraine to Myanmar? And within that, I'm hoping you can talk a little bit on what a responsible exit means, because there's been a lot of that within the context of Myanmar, and a lot of irresponsibility, as Shahad indicated, or a lot of irresponsibility in the exit within the context of Ukraine. So Celia.
Yeah, sure. I mean, fascinating, and it's always formidable to follow a very clear presentation on issues such as complicity that Shahad gave. And I'm really glad she talked about contributing to and benefiting from. It's that benefiting from that's often missed in this debate. So I want to come to some of that theoretical concept of war economies later as we go along. First of all, no two countries are alike, right? I mean, we all know that. And Myanmar presents a peculiar set of problems compared to Ukraine or Russia, for that matter, because Ukraine and Russia are war economies, and Myanmar in some senses is, because of course there are these, border clashes and ethnic groups. Some of them are still violent, and the Tatmadaw, the army, is still fighting certain battles. And clearly the whole Rohingya issue is something we cannot completely brush aside. So to that extent, it resembles a war economy. But unlike Ukraine, and arguably even unlike Russia, Myanmar genuinely has a government that is not legitimate. Russia, whatever you call, however, whether the elections were rigged or not, the fact is that Putin was elected through some process, and same with President Zelensky. So you're not talking about illegitimate governments here, whereas in Myanmar, whether the military and whoever is in charge of it right now has the legitimacy to perform the roles they are playing is a different one. That places in a different context, because if companies which are in a situation like Myanmar or Ukraine or Russia, they have to figure out why they are taking the steps that they're taking. If they're upset about a coup, then they have to think very carefully about it, because there are many, many countries which will have coups sooner or later, and governments which are not seen as legitimate in the eyes of the voters may be in power. Governments which are not respectful of human rights may be in power, and there are dozens and dozens of them, and there's a democracy deficit and decline. I mean, if you look at the Freedom House report and other reports, we will find that more and more countries are on a downward slide. So then what do? Do you do business only in New Zealand and Norway? I mean, that's a kind of question that comes up. So you have to be very careful about what you wish for, because you might get it, and it may create precedents, which may be even harder for companies. That it may be easy for a company to leave Myanmar because it's a relatively small part of a company's business. But can you do that with Saudi Arabia, with India, with China? Issues like that. We talk about Israel and Palestine, but China and Tibet and Xinjiang is an example. India and Kashmir is an example. In all those cases, there is a legitimate resistance going on, legitimate questioning of the authority that's going on. In that case, should companies start acting and playing the role of a duty bearer? I mean, Tara, both you and Shah talked about the responsibility to protect, which is great if that responsibility is inconsistent with international human rights standards. But do we really want to go back to a situation where companies are determining foreign policy? Companies are ruling states. I grew up in India, East India Company. I'll never forget that. And, which came to trade and ended up deciding, and, without mandate, without expertise, without accountability, without experience, and certainly without any legitimacy. So I think we have to be very careful about what we wish for when we ask companies to do certain things, because it may be fine, when they take a stand against apartheid. It may be fine if they take a stand when they're actually complicit in the occupied territories, but it may get more difficult as we go along. In Myanmar's case, yes, the center is still around. I mean, it's there. It's not an easy job because companies are slowly pulling out one by one, and we can talk about Telenor and Total and cases like that that have happened. It's certainly worth bearing in mind. And what we have to also think about, what are the drivers for these decisions? Because very often, I may sound a bit cynical here, but very often the decision is driven less by the human rights consequences on the community or the people or the civilian, and more by reputation. And when I really don't have an opinion on whether McDonald's and Starbucks should remain in Russia, for example. By their pulling out, people will have different kinds of coffee or no coffee, or they won't be able to have a burger. And lots of people, probably thousands of young Russians, will lose jobs. Now, whether that is undermining Putin or whether it is strengthening Putin to tell the people that, look, the whole world is ganging up against me, is the kind of questions companies have to take into account. But if they don't do that, then they will have petitions outside because you are fighting. I mean, your profits are Russian blood or Ukrainian blood. That kind of a campaigning can start again. So it's a very delicate act of balancing, and the decision is pretty much made out of reputational concerns in the bigger markets, and it has less to do with what's happening. So we have to be very clear about why companies are taking certain steps that do. That said, I think that contributing to and benefiting from framework that Shahad gave about defining complicity is very crucial. Many, many years ago, about 20 years ago, when I was at Amnesty, I had written a paper on what complicity means, and we looked at terms that, I'm not a lawyer, but many of you are. So it'll all, I mean, all the three of you are human rights law, if not lawyers yourself. So, aiding and abetting, known and should have known, mens rea, actus reus, all these concepts become very critical for companies. That are you doing something that's, so, I mean, the framework we had come was your proximity to the violation, violator, and victim. And in that context, are you aiding and abetting? Did you know about it? When did you know? How long has it been going on? Did you benefit from it? And did you intend for that to happen? These are the kind of questions that companies have to grapple with. And I think which is where the whole Myanmar case becomes very interesting, that you had two, I mean, there's several companies have pulled out, but let's take three examples right now. One is Telenor, one is Total, and the third is Adani Group of India. Now, the Telenor group essentially pulled out because had it stayed on, it would have been violating EU sanctions. And what were those sanctions? The sanctions essentially said that if you are there and if you are asked to provide certain surveillance technology, and if the state does not have good data protection law, then you cannot do that. And Telenor says that its hands were tied. I believe that, because I do think that, by being there, what the civil society and the community would love a company like Telenor to be in Myanmar, because if it is there in Myanmar and operating there, we expect it to fight the good fight. But the question is that should it be a company that's fighting the good fight, or should it be EU and the US and the ASEAN and South Asian Association of Regional and the United Nations? Why are we expecting companies to fight the battles that should be fought by the international community? And it's an open question about that. Total, on the other hand, had a different dilemma. It provides, it's a small part of its global business portfolio, but it provided about half the energy that the city of Yangon gets. Largest city in the country, commercial capital, probably a few million people who live there. I don't have the exact figure at the tip of my tongue. Their electricity supply, who gets it? Now, of course, somebody can replace it, just as somebody has now replaced Telenor. But do we want a company that adheres to certain standards to be there in terms of electricity? Suppose tomorrow they were to say there's a part of Yangon where the Rohingyas live. I'm a completely hypothetical example. And the government says have a blackout there. Another company might do it, and Total might say, no, we have a universal service obligation. Now, this is a complete hypothetical scenario. But my point is that, certain companies which claim to adhere to international human rights standard, we can expect those companies to speak in a specific way. So that becomes a crucial point to bear in mind. The final point that I want to make in this regard is the one about the Adani Group, which essentially is, I believe, pulling out of the port project that it was going to, because it would affect its ability to raise capital overseas, because it's listed in international stock market and there were sanctions coming in. So I think what we want to look at when we look at these situations is we want greater clarity from states. States need to be clear about the sanctions that they have. States need to have smarter sanctions and not blunt sanctions. So we all know that the sanctions on Iraq were a very bad idea. It led to shortages of baby food, medicines, and food, and all kinds of things, and that was hurting the civilians in Iraq. Whereas the smart sanctions, like the ones on conflict diamonds in Liberia and Sierra Leone, those were good examples of sanctions because they targeted specific wrongdoers. And I think the world has moved on from that. The SDN designations we get from the State Department is one example. EU has a list of designated notified people that you cannot, the Magnitsky Act that more and more countries are following about targeting specific individuals. That is the way to go forward. There are cases of that kind happening in Myanmar, specific companies. So if your partner in Myanmar is the MOGI, the Myanmar Oil and Gas Enterprise, or companies affiliated with the military, then it's a warning sign. But if it's a young entrepreneur who has come to Myanmar after 2015 when it seems so hopeful and has a small factory which makes garments and employs 20,000 women, is that the business that people want to hurt? And what are the consequences of that? So it becomes a much more multi-layered question about whether to stay or go. It's never an easy decision. And companies that are in a direct role of contributing to the society by, such as water supply, food distribution, healthcare, hospital equipment, providing nurses if they're a migrant workers rights organization or anything like that. If those are the kind of activities that are being done, then even if it's a war economy, businesses should be there. ICRC, the keeper of the international humanitarian law, has never said that companies have to pull out. I mean, all it says is that when you're there, follow the law. And I think that becomes a crucial point. But as Telenor discovered, and as other companies are discovering, if in the process of being there, and if in the process of working there, your actions are contributing to the violence and no other redeeming value, then distancing yourself is good because it reduces the risk of complicity. It reduces the risk of prosecutions. Of course, there have been very few prosecutions, but we do know the Nuremberg trials, we do know the Tokyo Tribunal, and we also know what happened to Holcim in France over the situation in Syria. I can talk about many more stories, but I think I'll pause there, I think, yeah.
Thanks, Celia. That was fantastic. I want to just note the things that I took, the primary things I took away from Celia's talk was that we really need to think about what we want from businesses and what we're asking of businesses and why we're making those choices as an international community. Because I agree with him, we don't want to go back to a point where our foreign policies and our international human rights discourse are being controlled by corporations or defined by corporations, because that does tend to lead down the wrong path. It then becomes a question of who enforces the foreign policy of states as well, and why we are asking oftentimes, and again, I'm going to go back to the arms industry here, where there is a level to which we are starting to ask them to enforce IHL because the international community doesn't want to do it themselves. And that can lead to some serious problems. I can talk a little bit about that later if we want to or not, but we need greater clarity on sanctions, and we need greater precision, or what Celia called smart sanctions. I want to also note, because between Shahad and Celia, we have come up with a couple of different terms around complicity and what we mean by it. There's complicity, there's aiding and abetting, there's contributing to and benefiting from within the OHCHR's database on settlements. And in the guiding principles, of course, it's cause, contribute, or directly linked to. So businesses owe reparations if they cause or contribute to a harm. They need to take mitigating actions and think about using their leverage if they are directly linked to the harm. And so that's an actually different paradigm than what we talk about when it comes to complicity, either from an international or from a domestic law perspective. So when we're looking at our enforcement regimes, right now we do have a bit of a terminological gap there. We're starting to see that closed with some of the human rights due diligence legislation out of places like France and Germany. I'm leaving the EU aside for right now. If the EU wants praise, they have to earn it, and you haven't earned it yet. So let's set them aside. But France in particular has done some important work in closing that gap of terminology by instituting its human rights due diligence laws. But there is still a gap, and as Shahad said, and as it became clear with what Celia said, we're in this place of flux right now in terms of what it is that we're expecting of corporations and what standards they're going to be held to. So they need to be paying attention to a wide range of things, whether it's international criminal law, sanctions regimes. The Magnitsky Act, which for those of you who are not familiar with it, originated in the United States, but has now been adopted in several other countries. And it is a means of sanctioning individuals who are responsible for particularly gross or severe violations of human rights. And so that is being used quite robustly in the context of Russia and Ukraine. So Avery, I'm going to come to you. And I wanted to ask you first to sort of introduce the work of the CLASP Lab, because I think it's a quite, I'm completely unbiased here. I've been a part of the CLASP Lab. This is my full disclosure here. By the way, when we're talking about my unbiasedness, like if it hasn't become clear in past events, most of these events are just me inviting people that I'm huge fans of, that I love and adore and sometimes stalk on Twitter. And asking them to come and talk to me about things that I want to talk about in this, and this is a continuation of that. I've been a part of the CLASP Lab because I believe in the work that the Corporate Accountability Lab, De Justicia, and ACA have been. I was afraid I was going to get that last acronym wrong. That they've been doing around bringing together grassroots organizations to really talk through how we pursue accountability and what lessons we have to learn from one another to create a more coherent approach to these issues. I may have actually just stolen part of your answer, Avery, so apologies, but let me ask you to introduce the work of the CLASP Lab. And also with that more sort of multiple armed conflicts and multiple lessons that we've learned from Colombia, from Liberia, from I'm going to blank on every other place. Sudan has been a huge part of this, the DRC, Uganda. You know, as we've talked through this over the past year, what have you taken away and what do you think Ukraine needs to take away from those lessons, and what can those other states be learning from Ukraine?
Yeah, thanks so much, Tara. And thanks for having me. It's an honor to be here. And I've been just so interested to hear the comments from Shahad and Salil. So I'm glad to be part of the panel and to bring a perspective from the Corporate Liability and Sustainable Peace Lab, which I'll introduce. But just by way of sort of introduction, I think what this perspective from the CLASP Lab can offer is looking at conflict settings in business roles in conflict settings that are winding down or are now in a transitional justice phase. And so when we think about what are we expecting from businesses in Ukraine or in Russia, we can look to some of these past experiences and see really what went wrong, and in the few circumstances, what went right, and apply those to these current circumstances and hopefully future circumstances as well. So I'll introduce the CLASP Lab briefly. The CLASP Lab is an initiative by Corporate Accountability Lab, another sort of lab, which is a nonprofit organization where I'm a human rights attorney. CAL, Corporate Accountability Lab, focuses on mainly accountability for multinational corporations who are complicit or benefit from abuses of human rights in the environment, mainly abroad, particularly in the global south. Through this work, we've really seen that there is a huge impunity gap for abuses of human rights in the environment in conflict settings. And so what we did is partner with the African Coalition for Corporate Accountability, ACA, the Comisión Intereclesial de Justicia y Paz, which is a Colombian organization, and De Justicia, another Colombian organization, to create this Corporate Liability and Sustainable Peace Lab, which is a long acronym that we call the CLASP Lab. And this was a year-long project where we convened folks from 25 countries, mainly in Africa and Latin America. The group included social justice lawyers who are involved in corporate accountability initiatives in transitional and post-conflict settings. We were lucky to have a few impacted community members, so representatives of communities who had been directly impacted by corporate abuse. And then also some academics like Tara, who we were thrilled to have sort of a global perspective and expertise on business and human rights more generally. So this was the sort of makeup of this group that we convened over the last year. This was honestly a COVID sort of innovation. We had hoped that this would be an in-person space where we could share experiences and crowdsource ideas together. for a few days. It ended up being a year-long project where we met virtually, and we learned a lot along the way in terms of how to facilitate a live conversation in 3 languages. We were operating in French, Spanish, English. But at the end of the day, we really wanted to bring folks together to talk about impunity for corporate abuse of human rights in these settings and how to hold companies accountable after the fact. And one, I guess, another goal that I think is important to share is we're thinking about how we can innovate together. So looking at the barriers to accountability and the drivers of impunity in transitional and post-conflict settings, and thinking about how could we innovate and how could we push for more accountability through transitional justice mechanisms like truth commissions and special jurisdictions for peace, but also parallel mechanisms like ordinary justice systems. So one thing that we did and we're still working on is thinking about how we can create new systems and new initiatives for accountability that can be hopefully tested in certain jurisdictions and replicated in others, and of course tweaked for particular contexts. So this is, I mean, that's a very brief overview of what the Corporate Accountability and Corporate Liability and Sustainable Peace Lab was and is. I personally learned a great deal about, business complicity and just involvement in conflict settings around the world. So I'll share a couple of things that I learned. We had folks from, again, 25 countries, I think, experience in about 35 or 40 countries around the world. And so I'll just go through some of the things that really stood out to me from hearing their experiences and both in directly living through corporate abuse of human rights and then trying to hold companies accountable after the fact, after abuses had taken place. So the first thing that I think really stood out to me was the level and really sort of visceral impact of violence and human rights abuses through a gendered lens. So we really saw time and time again in what participants were bringing up, whether it was in the Colombian context, particularly with Amerisur, an extractive company there, or in the Sudanese context with the London extractive group there, we really saw impacts on women and girls of people who have had their reproductive health impacted, for example, by environmental, by sort of water contamination or other impacts on the environment. We saw, of course, gender and sexual-based violence. So that was something that really stood out, and I think is probably obvious when you think about just conflict in general, but particularly in the business and human rights space, looking at the gendered impacts of business presence, and then also complicity of in financing of abuses by other actors. That was something that really stood out. Another thing that I think we saw time and time again, whether it was looking at the Colombian context or places in Central America, or even Sudan and other places, is in Syria as well, is the financing of armed groups who companies knew or should have known were committing, for example, crimes against humanity, sexual and gender-based violence, who were displacing people. And this was often, I think companies would probably argue, in the normal course of business in a conflict setting. So in order to sort of, keep operations running, companies would often hire their own security forces who would then either from direct instruction from companies or on their own, engage in human rights abuses, or companies would also enter into contracts with police and military who would then commit abuses against civilian populations, or then illegal armed groups, for example, like the Autodefensas, the paramilitary groups in Colombia, were a big beneficiary of corporate financing in the Colombian context. So that's something we just saw time and time again, which I think should offer some insight into what companies should look out for and be aware of in Ukraine and elsewhere. Another thing that we saw time and time again was companies benefiting from displacement. So looking at displacement of civilian populations of families from places where they live, where then companies can buy land for cheap or free and expand operations there, which then obviously has a long-term impact when companies are expanding and solidifying their power in places where they otherwise might not have just the physical space to do so. So that's something we saw. And one thing that I think hasn't been, I haven't commented and I don't think I've heard it for the other panelists yet, is the impact and potential dangers on labor rights. So we've seen time and again, both countries who use conflict as an opportunity to really squeeze, freedom of association. I know that's happening in Ukraine right now. There's been a temporary, I think, suspension of some labor rights there, which may become more permanent. And this is something that we've seen in different places. For example, in Colombia, there was definitely a sort of an opportunistic involvement of companies in using armed groups to target labor organizers, both in terms of torture and alleged assassinations. So that's another thing. I would say that just to wrap up, a couple other things that really stood out to me from the class lab were that there is really post-conflict and in transitional justice settings, by and large, impunity for actors who are not direct combatants. So when you're thinking about corporate involvement, financiers of conflict, there's really in transitional justice settings and there's mechanisms a lack of focus on those actors, even though if the goal of transitional justice is sustainable peace and prevention of abuses in the future, you've got to look at all actors and the role that companies have played in conflict. And we also see that it's not only, I think, on countries that are entering into transitional justice phases, it's not only on them to look at the role of companies in past conflict settings, but also in home countries where multinationals are based. So, for example, when I think about the Colombian conflict, I think about the many US-based companies that financed armed groups there that benefited from conflict. And it's also, I think, on the United States to be able to at least provide forums where victims of abuses can seek justice. So I think I'll stop there, but those are some things that we saw time and time again from, again, folks from about 25 countries in Africa and Latin America, looking at business involvement in conflict settings. So I'll stop there, Tara, but I'm happy to talk more further on in the panel. Tara, you're muted.
Man, like, give me one more year and I will have figured out Zoom. My key takeaways there, thanks, Avery, were that gendered impacts require a gendered lens for understanding our responsibilities going forward. And we need to be really thinking through the gendered impacts of how businesses operate, generally speaking, but particularly in situations of conflict. We need to think through about the complicity and financing of other actors, and we need to start talking about that. I hope that we come back to that in the Q&A. I'm going to encourage you guys again to the participants to use that Q&A function at the bottom of your screen to ask questions. That there's been historically, and I think we're seeing this again, some financing of armed groups that we knew or should have known were engaged in widespread systematic violations of human rights and humanitarian law. Here, I'm going to take a pause and add to what Avery said and give credit to the Ukrainian government for really taking justice in Ukraine for violations of humanitarian law quite seriously. There was a very famous prosecution this week of a Russian soldier, and it's a significant credit to the Ukrainian justice system that soldier was provided with competent counsel, established counsel, significantly impressive counsel, and it's a credit to that counsel that he took on that role, because we need that for real accountability, for actual accountability in these contexts. And then finally, we need to think, two final points is impact and potential damages on labor rights, which do often, I have to admit, I often forget to think about the labor rights side of these things. And then these large levels of impunity that we see for corporate actors really needs to be, it's a communal responsibility rather than an individual responsibility. And I want to hear echo and potentially build on Avery. I don't want to speak for her when I say this, but I think that there's a lot to be said about the fact that when states are in post-conflict societies or post-conflict transitions, they are balancing and juggling so many competing needs, right? So there's development, sustainable development needs, there's new economic activity needs, there's the establishment of peace, and there's the establishment of justice. And these things can pull in different ways against the state's ability, and they all require a vast commitment of resources, both financial and personnel. And so asking them to accomplish all of that on their own without significant support from home states is really an unfair ask. It's one that we consistently make. It's one that I will always make, but it's also, I recognize that sometimes my own asks are unfair because we need greater support from the international community. So I have 3 more questions for the panelists. I'm going to ask that we keep the answers to these questions somewhat shorter so that we can have a lot of time for Q&A from the participants. But when we talk about heightened due diligence, this came up a few times, that the expectation in situations of armed conflict under the guiding principles is one of heightened due diligence, or what's sometimes called enhanced due diligence. What does that mean for businesses? What do we want from businesses? And how has Ukraine differed from or added to our knowledge of what businesses should be looking for in these contexts? So Avery, you are still popped up on my screen, so I'm going to turn it back to you, and then I'll go to Celia and then Shahad.
Thanks, Tara. Yeah, I think when it comes to heightened due diligence, I would say I think Shahad is probably going to say this, but I took some notes when she was speaking first, and just saying that we should be looking beyond companies who might possibly violate international law because those standards are evolving. We should be looking at how companies can avoid contributing to economies that perpetuate violence. I think there's a very real possibility of liability for crimes against humanity and other things that happen in conflict settings that are evolving, but we should be looking beyond that as well. I think just to the other couple of things that I would add are that companies really have to understand risks to labor rights, whether that is, whether state laws are evolving that allow people to be fired or their work suspended in conflict settings. It's still a risk that companies need to keep in mind. I think the risk of corruption is obviously heightened in conflict settings. And I think just the other thing I would highlight that stands out to me is that the risk of paying for security, whether it's from police or military or illegal armed groups or others, there's going to be a very grave risk of contributing to actors who are then committing systemic human rights abuses that companies should keep in mind and absolutely avoid.
Thanks, Avery. Salil?
Yeah, I agree with everything Avery has said. Just to add 2 more points. I mean, yes, it's true that laws are evolving, but we also have very hard law in terms of international criminal law and international crimes law, which does apply to companies. Companies often tend to disregard it because of this assumption that how can we, with all our values, be implicated in cases like that, We are a fine Scandinavian company, and how can we, but then you scratch where they are a wood trading company, and where the wood comes from, it's Liberia, and Liberia is Charles Taylor, and then it becomes much closer than you imagine it to be. So explore those relationships very clearly, see who is the beneficiary, see what you are benefiting from that, and what are you doing with it. And that is linked to 2 other minor points that I want to add very quickly. One, companies should companies always say we are good corporate citizens in country A or B. And my point is, and therefore we are partners of that country's progress, which is great for a brochure. But I've always told, I mean, who am I to tell? But I've always told companies in tricky situations that remember that your long-term and durable relationship is going to be with the consumers, citizens, and communities around you, because the governments will come and go. So if you have a wonderful relationship with the dictator in the capital city, or the tyrant who runs the country, or the province for that matter, and ignore the people, then at some point the chickens will come home to roost. And when they will come home to roost, it will be very bad. Your pipelines will get attacked, your workers will get kidnapped. And when the new government comes to power, your license, legal license, may be taken away. And the third point, which goes as part of the heightened due diligence, is that if you're indeed loyal and committed to the communities, and this is where the Myanmar case becomes very vivid, that remember that your people are fighting for their democratic rights, those who are working for you. And if they're working for you and fighting for their rights and are nonviolent and peaceful of the CDM, the Civil Defense Movement, and if they're out on the streets and if they are arrested, see if you can give them legal support. See if you can attend their trial. See if you can visit them in jail and keep them on the payroll. If possible, offer a similar job to someone in the family, but do things that demonstrates very, very clearly to the people that, look, we can't change the government. It is for you to do, and we respect your right to do so, so long as it is peaceful and democratic and all that. But we are there with you in this, because we want a stable government, which is a fine government, which is a sound government, which respects the right of the people. So this is slightly taking a step beyond, but this goes into the whole part of the quote unquote fulfillment of human rights, which is not a duty of the legal duty of the corporation, but what it can do if it wants to.
Thanks, Salil. Salil and I often play, I would say, complementary roles, in that Salil speaks to businesses a lot more than I do, and I am much more on the name and shame side of that continuum. And I think Salil does a really good job in bringing business.
I name and shame also.
No, you do, but you do it when needed, whereas I do it sometimes just because a business has pissed me off. So Ericsson and Lunden, that includes you right now. So when we talk about companies that say, oh, but our values are, how could we possibly, we have seen out of Sweden 2 companies that have faced war crimes prosecutions. Lunden for its role in Sudan, and Ericsson for its role in Syria and Iraq around ISIS. And in both situations, they did have that sort of same, oh, but we couldn't possibly, and how can you expect us to have known? And what else would we have done? I mean, what else would we have done is a really simple answer, like, don't pay ISIS. I mean, or, you know, I recognize sometimes that gets into really tricky territory, but, you know, take this more proactive role. And I think Salil, you have really done a strong job there of laying out additional options for these companies when they're operating.
And if I may add one thing, I mean, you know, Lunden's case, which I know quite well because it's been going on 20 years. Huh? And Amnesty used to have conversations with Lunden at that time. Just for Lunden to say that we did not know, or how would we have known, then have a nice tower in Paris to sell them. Yeah.
Yeah, we're going to come back to that with my next question around, like, when can we expect them to know? But Shahad, I want to give you a chance to answer that first question about heightened due diligence, and then I'm going to start with you again and go back, and then.
Okay, so when I usually explain to my students the industrials trials, which is the biggest the kind of accountability example we have for corporations, a very big question is, well, could they have known, and has the regime and the way of thinking changed? So my advice usually is that eventually things might change, and the legal framework you're looking at might change. And when things look all right, this might stop looking all right when the status quo changes. So at the end of the day, deciding to invest in a risky place means that you're going to get a lot of profit. You can't deny that investing in a place that is risky, or investing in the Russian in the Russian economy, investing in multiple economies that have been either ravished by war or under risk of war, actually opens up lots of lucrative spaces. So you as a business have to be really aware of the fact that when you take such a decision that will get you a lot of money, that you are participating in a very high risk environment. As a very high risk environment, you have to be willing to pay the price. And the price is that, and is that you will have to keep in mind that you will be losing a lot of money in specific cases. And if not, evidence has shown that corporations that kind of avoided that thinking, like for example, G4S, GCB, who are GCB or Caterpillar are selling bulldozers. They wouldn't have expected this. They go on the presumption that it's a commercial activity of simply selling something. But at the end of the day, knowing that you partake in the war economy in one way or the other means that you have to have, let's say, a wider spectrum of understanding how at the end of the day you would be feeding into violence. And it does sound complicated for the compliance department, because the compliance department are really looking into the minimal thing that the corporation has to do, which brings me back to the idea that, and I'm really sorry for pronouncing her name wrongly, Biet Sajafel, who was at the University of Oslo, who said that at the end of the day, if we were to have actually a good application of the business and human rights discourse, we need a shift in corporate governance, and we need a shift beyond the profit maximization mentality. And this shift seriously needs to happen in the compliance department, because thinking simply in terms of how to maximize profit while keeping as much as possible, complying will at the moment put you at a jeopardy for the future, because eventually things will have to change, and the evidence is growing higher. Also, just to add, a very big thing of going beyond the compliance paradigm is always having plans for your labor. This is the learned lesson from Lafarge, and not to discriminate between your labor and also having a local eye to understanding the risk. I think a lot of corporations do forget that you need a local expert to give you exactly what are the risks that you are holding to fulfill the heightened space that you need. And again, the willingness to lose. And the thing is that we've learned from Ukraine is it is possible. Corporations are willing to lose and are willing to partake in this. And Ukraine actually should give us this push. And in the business and human rights discourse, we should harness this push towards divestment in actually saying that at the end of the day, you are willing to do this. Just do it in a more well thought of way, perhaps, and in a way where you can see it. But you have just proved to us that this is the price that needs to be paid.
Yes, absolutely. And thank you to all three of you for that. I want to pick up on two things that Shahad said. The first is heightened due diligence does require a local eye. It requires a local understanding of the conflict. I think this is something that businesses too often miss, and too often miss meaning I have had businesses approach me and ask me to do human rights due diligence in a situation of armed conflict in a country that I cannot go to, right? Like, as a woman, as an American, there are certain places that, I mean, the likelihood that I'm going to be killed vastly outweighs the likelihood that I will do good. And at that point, I'm not going to do human rights due diligence. And when your follow-up is, oh, but can't you just do it from a desk? The answer is no. The answer is always no, but it's particularly no in a situation of armed conflict. So when we talk about heightened due diligence, it's the fluidity of the situation that you really need to understand. And generally speaking, that requires someone who's local to be giving you guidance as to what you're doing. And if you are stuck and you cannot find local actors, don't go in, or figure out how to leave responsibly. But the idea that you can continue to operate in a situation surrounded by immense violence without becoming complicit, without having that local eye, it's not going to work. You are going to find yourself in a situation where things change, which is the second thing that I wanted to pick up, which is this idea that things do change. And often when they change, the question isn't, were you legally complying? The question is, should you have known that what you were doing was wrong? And we saw this following the end of apartheid. The Truth and Reconciliation Commission didn't just say, oh, well, what they did was fine. So it's, it was legally okay to exploit minors at different rates based off of their race. It was legally okay to finance the apartheid regime. So c'est la vie, let's move forward. That's not the standard that was applied. It's not the standard that's been applied in South Africa. It's not the standard that's being applied elsewhere. It's not the standard that's being applied in Colombia. The idea that something was legally acceptable at the time doesn't give you absolution. Once things have changed and people look back and say, look, Chiquita, you shouldn't have been funding these people. Or look, other company, you shouldn't have been exploiting, you shouldn't have taken this land. It doesn't matter that the transfer of title was there. Look, companies operating in Syria, taking over property that's been expropriated under law number 10 isn't justifiable. So you will see that change. And that brings me to my next question, which is, when Russia invaded, there was a lot of shock because I think people wanted to believe that it wouldn't happen. But when we look at the situation, there were a lot of warning signs. So Russia has been illegally occupying Ukraine since 2014. That's a really uncomfortable reality for a lot of businesses and a lot of states to be talking about, but they have been illegally occupying Ukraine since 2014. What we're talking about now is an expansion of where they're illegally occupying. That's not the only space that Russia has been illegally occupying. They illegally occupy portions of Moldova and portions of Georgia. There have been a lot of other indications of significant, widespread, and systematic violations of human rights within Russia, including within situations of armed conflict like Chechnya. So it perhaps played out differently than people anticipated. It played out sooner than I think a lot of people anticipated. But there were these big red flags out there. And so when should we be looking to hold businesses to account for their relationship with Russia and with Russian weapons manufacturers, Russian military, oligarchs from 2014 to now? So there's a lot of recognition that moving forward from February now, we can talk about accountability, but what about that period from 2014 to present? And how far back do we go when we talk about the business's responsibilities in these contexts? So Shahad, I said I would start with you. I'll go to Salil and then Avery, and then Salil, I will start with you for our final question.
So just briefly, and also just to add, Russia has been a proxy actor in Syria for quite a long time. And just because the legal framework is incapable of capturing that, its money is the main reason why that country is still incapable of going up. So and even like we can even start talking about corporate involvement in leading the Russian economy towards sustaining that, especially in the arms industry. But also, and my answer to your question is actually I find it to be very industry specific. So I think for example, with the fencing files, we had a number of banks where there was actually a lot of illegitimate transactions that were caught in relation to Russian oligarchs, and then links to money laundering, other links to kind of putting together that money that feeds into the Russian military industrial complex. So I think we can start to talk about complicity in generally the military industrial complex, because that military industrial complex is actually very easily complicit, as you kindly mentioned, in multiple war economies. So that is something that they could have anticipated, and they could have anticipated actually from my perspective as early as 2015, 2014, and specifically when it comes to oil and gas corporations and banks. These two are quite important in ensuring the expansion and the development of the military of the Russian military in a way that facilitated what happened now. Was this anticipated? Well, the question of its anticipation would be quite a bit hard to prove in terms of in courts, and specifically in this case, the standards that we have are still not developed enough, especially that our understanding of corporate mens rea is still at baby stages. But it is very safe to say that there was very big question marks on investments in relation to Russia from a long time ago. And if we were to have further corporate transparency, we would know how far that complicity has gone.
Thanks, Shahad. Salil.
Yeah, a couple of points. One is that in the chat, I have put the link to a report that I had co-written in 2002 about the human rights risks of doing business in the Russian Federation, which we had launched in Davos at the World Economic Forum. Irene Khan was the Secretary General at Amnesty. I'd written most of that report. And when we did launch it, we met two very prominent business people, one Russian, one non-Russian, who were doing brilliantly in Russia at that time. And they kind of poo-pooed our concern. They said, oh, it's not that bad. All I can see that they're both in exile in another country now, and most of their assets have been taken away. So if only they had read that report in 2002 and taken it more seriously, we might have a different, but more seriously than that, look, we did not, as you know, Shad, you pointed, and Tara, you also pointed out, we knew about Russia and Ukraine in 2014. I was in Lviv in Western Ukraine in 2017, I think, for a literary conference. And I met a lot of Ukrainian writers who were stressing the importance of repeating truth because we are being attacked by falsehoods and, rewriting of history and fake news. So those who wanted to knew the warning signs were there. They chose to ignore because they thought it was a risk worth taking, partly because they thought Russia will not go and attack, or partly they thought, as Shahad was pointing out, the profit potential was too strong. And in this, it's military and industrial complexes, but even the financial nexus. So much of the Russian money resides abroad. People were very happy buying their yachts and properties and so on, and nobody wanted to disrupt that flow. So warning signs were there, and I dare say such warning signs exist everywhere. Most companies have some people within an organization that know where to look for. What they choose to do with it is with them. And sometimes being the canary in the mine, you are shouted down because they just feel that, you're being a Cassandra and you're not needed. But the fact is that one has to listen to these voices and at least try to secure the position so that when things do go bad, there is an extremely good plan in place to make sure that the exit is responsible and safe.
Thanks, Celia. Avery.
Yeah, thanks, Tara. I think I would just echo my fellow panelists and just saying that in the Ukrainian context, I think there were warning signs since 2014 and 15, and businesses should have had this on their radar. I think generally the possibility of conflict and the escalation of violence should generally be on companies' radars. It's not coming out of nowhere. I think there are plenty of contexts, perhaps almost all contexts, where the possibility of escalation of violence is just something that companies should be thinking about in advance. And then just the other point I would make is that I think in terms of legal standards and potential liability, legal definitions of conflict for international humanitarian law, international human rights law are important, obviously should probably be expanded to be a little more inclusive. But I think this question is really interesting. The question about, how long should we be looking for accountability for corporate involvement in some of these conflict settings, I think speaks to a more general question about the role of corporations in facilitating violence in our society. I think, in the United States context, I'm just thinking about what is conflict, not in terms of a legal definition, but are we seeing a low level conflict, against African Americans and other people of color in the United States by police and other armed actors? I would say yes, it's a low level conflict. Doesn't meet the legal definitions necessarily for conflict, but what is the role of companies in facilitating that type of violence? So I would just say that I think this question is super interesting. Yes, for the legal definitions, but also what is the role of companies in facilitating violence, like police violence, but also inequality. I think that's a type of violence too. So thanks for the question.
Yeah, no, I think that's brilliant. And actually you're giving me an opening to talk about two other things. I know I'm not on the panel, but I'm just going to keep abusing my power here. And the first is, yes, low level conflict in the United States is a real thing. And I think companies need to remember that what the UN guiding principles talk about are conflict affected areas, specifically to avoid setting the bar only at situations where there is an ongoing armed conflict, which has a legal definition to it. And that's because the period before conflict is the ramp up period, and the period after the conflict, you're still in that conflict affected area. You still need to be aware of your ability to exacerbate the conflict, to facilitate the conflict, to contribute to, or to benefit from it. And so in situations like the United States, Avery, as soon as you sort of said very early on about thinking through in all situations, that's exactly what came to my mind. We saw in the past week white supremacist violence in the United States. We saw again tragically yesterday the killing of children in the US. And there's a question there about the responsibility of arms manufacturers, but not just arms manufacturers, others who feed into that, including investors, institutional investors, financiers, banks, and others. And I think within that, the other part of what you said about thinking through inequality as a form of violence, one of the indicators of whether an armed conflict is going to erupt in a society is how power is distributed between identifiable groups. Social scientists who work on this talk about sort of four areas of power, which is civil power, political power, economic power, and cultural power. And the more unbalanced that distribution of power is, the more likely an armed conflict is to erupt. And so when we talk about conflict affected areas, we're not talking about, oh, look, somebody finally started an armed conflict. You know, it's not the moment that Assad starts shooting Arab Spring protesters. There is a buildup to that period that businesses need to be using this conflict affected lens on and really thinking through what are our indicators, where are we now, what are we doing to contribute to? So I'm really grateful, Avery, for you bringing all of that up. Now, the final thing relates to my final question before we go to the participant questions is on the issue of corporate accountability. It's been touched on a few times throughout this, but let's talk again about what home states should be doing right now and what should investors be looking at? And then finally, what should parent companies be looking at? Because those are three key actors when we talk about what's going on in Ukraine. Here, I want to again highlight my respect for the Ukrainian Ministry of Justice for their ongoing efforts to secure evidence about war crimes in the midst of the armed conflict. I don't know of another situation, at least when I think through it, other situations don't come to mind, where we're seeing the kind of live gathering of evidence of war crimes in the midst of the armed conflict at the level that we're seeing with Ukraine. So I've given them a lot of kudos today. They have earned those kudos. So Celia, let me start with you. What should we be looking at from home states, investors, and parent companies?
Sure. Briskly, home states essentially have to step up to the plate and not abdicate their responsibility of foreign policy and hard decisions on the companies. They cannot merely hint and nudge that don't do this and don't do that, or if you do, you'll be, we won't like you. They have to give very clear guidance about what businesses can operate there, what cannot operate there, have the sanctions, and if they do impose sanctions, if they're violate, to prosecute the sanction busters. I mean, those are the minimum requirement of a home state. The question is always about extraterritorial application of the law, but we are talking about international crimes, and when it is an international crime, then there is a complicity issue. Foreign Corrupt Practices Act does allow a US government to sue a company that bribes an official abroad. So I think an imaginative interpretation, I know that the law does not permit applicability of domestic laws overseas, so I'm fully aware of that, but I think that's the kind of thing that this proposed treaty for international human rights and business that's being talked about should really be looking at, that when there are grave abuses and the company is from the home state, that law should apply there. Parent company liability cannot be washed away by saying that it's not our responsibility, it's somebody else who's doing it. I think then it needs to be there. Now, investors, I'm a bit hesitant to give, because it's very easy to say divest, but when you in a stock market, if the Norwegian pension fund pulls out, some hedge fund will buy that share and they'll be even less likely to do the right thing. Or if the Interfaith Center for Corporate Responsibility issues a statement that you pull out of this particular company, people might do that the Archbishop of Canterbury does that, Church of England does. All that is good, but who is going to replace it? That becomes the issue. And also it does not take into account two other fields. One is private capital and venture capital, and those are completely unlisted companies, those who directly go and strike a deal among a pool of investors. And there'll be lots of companies like that which will be able to go beneath the radar. So yes, focus on investors is important. Investors do play an extremely important, but as campaigners, as observers, as analysts, we should remember that's only part of the story. For that, we have to get the parent company to come on board, and most importantly, we have to get the home state to do what taxpayers and electorates want them to do.
Thanks, Salil. Avery, I'm going to come back to you, and I'm going to finish up with Shahad on this one.
Great, thanks. Yeah, I think I would definitely agree with Celia that in terms of home states, it's time to step up to the plate and need to provide concrete guidance. I think the implementation of the laws on the books, so not just saying, oh, we have the Foreign Corrupt Practices Act in the United States, or oh, we have the possibility of imposing Magnitsky sanctions, actually imposing them and then following up on that and showing that this, type of complicity or benefiting from abuses and conflict is not something to be tolerated from home states. So I think that is an opportunity there. I think also conflicts are always an opportunity to revise what laws are we using, and where is there a gap, where is there impunity, and how could home states evolve their own legal systems to contribute to really a better world and to making sure that home states companies are not are facilitating conflict. So I think it's an opportunity to also advance and innovate. I think parent companies should know that, I think as we've said a few times in the discussion today, that law is evolving and the possibility of piercing the corporate veil is becoming very real. I mean, with the recent Lafarge decision and the indictments that have been confirmed. And I would agree with Shahad's earlier comment that that on the ground experts, and I think Tara as well said this, on the ground experts are not only necessary but essential. I mean, you have to have on the ground experts to know what's going on, and parent companies should be taking their guidance from those on the ground experts, and they need to be experts in human rights and conflict. And then in terms of investors, I would just say that, I agree that divestment can be tricky. I agree with Celia on that. I would say that investors should be looking to laws that require that companies are transparent with them and should be monitoring as closely as possible what companies are doing and using their power as shareholders as usefully as they can.
Thanks, Avery. Shahad?
Very quickly. So in terms of home states, I think there's already a lot of movement towards actually developing our understanding of corporate criminality. And in this sense, for example, in Germany now there's a level of evolution in establishing actually a very specific corporate criminality that's not criminal, that mixes in some civil aspects with corporate criminality. And this is something to actually look out for, and at the same time to actually endorse as much as possible. There is this poverty in our understanding of collective actors and how they are involved in mass atrocities, specifically also with how complicated the globalized economy now is. And so to incorporate an imaginary of how global value chains actually look like and how abuse could actually look like in the judiciary of states. And I think there is a movement towards that, but it's growing, but it should be growing. And I think that would actually allow a shift in corporate compliance, because then corporations would be, whether or not we like it, corporations adapt to whatever the home state is requiring them to do. So in order to comply actually with the Business and Human Rights Directive, I think this is something quite very big. And to show them, for example, with the case of Syria now, you see a lot of national litigation that is happening as a form of accountability for people. But then the frameworks, the corporate criminality frameworks are becoming so much more clear in a way that facilitates universal kind of accountability. So that should really be kept in mind. And the fact is that also you don't want to be an accomplice on an international level if you haven't done your job, which there would be a question about you at some point, especially when it comes to the arms industry, as was the case with the UK, for example, the campaign against the arms deals, the case where it was internally sued for facilitating arms deals, but it was by BAE Systems, but the UK was found to be guilty. And as for investors, aside from the always endless thing of please think long term, not short term, and please be aware of the value chain that you are getting yourself involved in. And the idea at the end of the day is that a lot of people do not realize actually how, or actually take a quick look or a deep look into how far their corporations are going. And actually another message to investors in this case is internal accountability is something that is quite very important. So an ethical investor is something that is a very hopeful thing in this world. So actually act and engage in the sense that is long term. And investors may not be apolitical. Being apolitical is a choice. If you are investing in, if you are deciding to take that much profit, then again, I repeat what I said before, you need to be really aware. And at the end of the day, you might end up putting a level of accountability on yourself, financial accountability, because at the end of the day, your corporation might end up losing a lot of money in litigation. As per parent corporations, as kindly noted by Avery, there is the Lafarge case, there is the Vedanta case, and especially in the context of war, we are seeing this increase towards linking corporations to their subsidiaries. And the thing is, I was actually talking to people a few days ago who were working on supply chains involving cotton that is produced in China, that is using forced labor by Uyghurs. So in that sense, what happens is that because you're not so aware of how far your supply chain goes and your suppliers, you end up getting yourself directly involved. And now there's litigation against corporations for sourcing that. So the framework is evolving, and at the same time, there is cause lawyering that is evolving in a way that is eventually at the end of the day bringing us back to the main focus that should happen in your thinking, protecting the people in the war economy and the subjects affected by the war economy.
Thanks to all three of you for those answers. That was really helpful and insightful. I just want to pick up on something, and I'm not 100% sure what it was that Shahad said that prompted me to write down Dutch banks really large on my notes. But I know it relates to the investors, because this week we've seen Dutch banks come out and ask for clarity over whether or not they could ever be complicit. Can they ever have caused or contributed to harms through their portfolio companies? And the answer is yes. The answer has been yes for several years. We know that the answer is yes. And I know that it becomes really complex, and there are legitimate questions around when should institutional investors stay invested and when should they leave, because if under the guiding principles, as we talked about before, if you cause or contribute, you're expected to provide reparations. If you're directly linked to the harm through something, you're expected to use your influence and use your leverage to affect change. And so traditionally, we've always thought that institutional investors, particularly pension funds, are really in that directly linked to category through their portfolio companies, and they should be using their leverage to affect change in their portfolios. But there comes a point in which the question is, have they been stuck for too long in that waiting period? Is there a likelihood to change? A few years ago, the Essex Business and Human Rights Project did a report on the Norwegian Investment Fund and its operations in Palestine, and we said, you have to leave. Like, whatever justification you have for staying in a normal circumstance does not function well in this particular circumstance of Palestine, because legally, there's nothing that can be done, right? Legally, the infrastructure is such that you cannot operate within that context anymore. You cannot invest in companies in that context anymore and still only be directly linked to. There's no way to not be complicit in the harms of the settlements. To my knowledge, they have not acted on that advice, but I think that if we don't see movement from institutional investors, if we don't see movement from pension funds, we are going to see civil liability claims coming up soon. And we will hopefully, and I do say it hopefully, see criminal prosecutions of some of these institutional investor leads because of their responsibility. So when we talk about that cost contribute directly linked to continuum, it is a continuum. It's one where businesses can, based off of the context, move from directly linked to into contributing to. There's a debate as to whether they can move on to cause, but at least between directly linked to and contributing to, there's some fluidity there. And that fluidity is at a greater level when it comes to situations of armed conflict than it is in normal circumstances, because everything it evolves in time, right? Like it evolves quite quickly, and so they have to be making those choices. I do have an article out on how we define cause, contribute, and directly link to. If you are interested, you can email me. I'm extraordinarily Googleable, so I will just leave you to Google me for that. So we talked about the need for local eyes. I'm going to point out that we graduate 100 students every year who are fluent in human rights from the University of Essex. So if you need your local eyes and ears on the ground to help you with due diligence, we probably have graduated somebody who can do that for you. Some of those people are here in attendance today. I forgot to give the disclosure around GDPR that this is being recorded. So I won't give you their names out loud, which I feel bad about. If either of them who have already used their names want me to name them, they can drop an extra question or something and tell me that, or something in the chat. But we have questions from recent and current Essex students who are doing some really cool things in terms of business and human rights or in terms of armed conflict. So the first is, we've seen from the current situation in Ukraine that sanctions play an important role in these conflict situations. The strong stance from the international community has definitely influenced the mass exodus of corporations from Russia. But what can be done when the international community fails to act, i.e. the absence of sanctions on Israel? And the second question, I'm gonna read 3 of them at once and then give you guys a chance to respond. The second question is, in terms of respecting labor rights in conflict settings and otherwise, does that not depend on the domestic law in the concerned states? In that context, why would businesses do anything above the minimum requirements of the law, especially as it may be better for their profits not to? And then the final question is, how can we evaluate the human rights risks caused by businesses dropping out of the Russian economy? And what does that do to the Russian population? So I'm going to give that to each of you. I want to note that on the issue of human rights risks from entering or leaving the economy, it does trigger issues of essential services. As we wrap up this event later, I'm going to bring the Ukrainian expert, Elena Uvarova. Elena, I'm so sorry. Every time I say your name too fast, I butcher it. So Elena Uvarova, who is doing some work around essential services in armed conflict. So we will bring her into the conversation at the end. For now, I'm going to come back to the 3 of you. Who wants to go first? None of them. So Avery, how about you?
No,
Oh, Shahad, sorry. Shahad, was that you unmuting yourself?
yeah. No, I was just reviewing the questions again. But the one that is registered with me is the sanctions one. And since this is within my field, I'll take the liberty. So the thing is with the sanctions regime, actually, is usually we look at it as to people like myself. It's a space where it's a rare place where actual level of accountability has happened, or a level of the world responding to something very violent. But at the same time, the main problem with the sanctions regime is, again, the same functionality that I've talked about before, is that at the end of the day, this very great tool of, well, if you are, if foreign actor is doing something wrong, to tell them, well, we're going to economically harm you, ends up being a very political tool. And also because it's that, it ends up not having, again, the people's rights at the heart of it. As seen, for example, with the sanctions on Syria, this ended up really harming people much more than helping them, and so many different ways. But the context of occupation is different, because in Syria we're talking about technically an internal conflict, but in an occupation you are talking about a direct act of domination, and this is something actually that I wanted to talk about before. So in that case, it's obvious. There is that party that is dominating another party. There is no discussion about it. So there is a party that lacks specific capacities, and in this case, for example, as we can see in terms of military power. And of course, in the case of Palestine, you're talking about absolute domination. Compare Palestinian military capacity in comparison to Israel's, which was one of the top 5 in the world, and Palestinian is almost non-existent, basically recycled arms. so in this case, the decision to partake in sanctions should be actually a bit clearer, and the decision of how to partake them should have more of an effect to protect people. But again, the problem of unilateral acts comes to the fore, and also the other problem of not putting into the accounts the creation of coping war economies, because at the end of the day, even with sanctioning Russia, this has facilitated opportunities for other people, and this has facilitated the growth of other people. So I think there is generally an absence in the sanctions regime of collective thought, and of collective thought that is geared towards the people. And again, we go back to the problem that the only way to have sanctions on a multilateral level is goes through the Security Council, which is the least just place to have that discussion, especially that it has all the guys who we have problems with usually. So any way out of that would be through collective work and through collective action that respects people, but that doesn't deny the power of sanctions in actually helping a level of movement, and also of normalizing the case of sanctions, especially in the case of Israel. But as you can see, just because the legal imaginary has still not evolved to realize how much violence there is there, and because of the politics that is there, such a powerful tool, people are still very much reluctant to use it, even in very, very progressive international law spaces.
Thanks, Shahad. I do have permission to note that question did come from Jenny Duncan, who finished the degree last year and is now working in the field of business and human rights. So yay, Jenny. Sorry. Avery, would you like to answer any of the questions?
Sure. I will take the labor rights question, which I think is really interesting, and a good point that yes, labor rights do depend on the domestic law of states. And I think the question is a fair one. Why would companies do anything beyond the minimum to respect labor rights? I would say this kind of gets back to the global problem of a global race to the bottom. I think we're seeing companies deliberately choose places to have their suppliers and sourcing countries in places that not only have low minimum wage laws, but that have very lax labor rights laws. And so I think when we look at it in that context, why would companies pay more than the minimum wage, or get around even exceptions to paying the minimum wage? I think that's a great question. I think a lot of times companies don't. I think when I think about multinational corporations, something that has proliferated in the absence of really more robust labor rights and human rights legislation in home countries or source countries is where I think about codes of conduct. And a lot of multinational companies do have codes of conduct that say that their suppliers and subcontractors all abide by minimum wage laws or even go beyond that. And then also that they respect labor rights. And so if that's something that a company has suggested that it does, in its own internal codes of conduct and contracts with suppliers, that's something that it absolutely has an obligation to do. So I would say, yes, maybe in practice, this is something that companies are going to go to the lowest common denominator. But I think that's a question that connects to other sort of global race to the bottom concerns, and companies should be thinking beyond the sort of eroding labor rights laws that we often see in conflict settings.
Thanks, Avery. Celia?
Yeah, a little bit on the labor rights and also on the final question. So labor rights, what I want to talk about is a concrete example, which is the accusation that Halliburton, Brown and Root and Carl had in Myanmar, because that's the kind of setting that's in a way more crucial to note in the context of conflict than the traditional supplier of t-shirt garment factories and minimum wages and all that. And because there what you had was forced labor. And yes, the question is right that that's a domestic law. But even if the companies were saying that we were merely complying with it, and you could argue that they were, because they wanted a certain number of workers to build the pipeline, and the military said, we will supply them. Some of them were shackled. And I know this for a fact because in 1992, when I was a journalist in Southeast Asia, the magazine where I used to work, we carried photographs of that. So, one of the photographers had gone down to take that and do the story. So it's not a made up story at all, right? And this was not necessarily the same pipeline. There were other pipelines being built too at that time. But the fact is that you do have that kind of a relationship which was well known. And the consequence of that was, of course, the lawsuit that was filed against Total and Unocal, both under the Alien Tort Statute and civil liabilities that, Avery, you were talking about. And I think Sherpa filed a suit in France against Total. And in both the instances, the companies did pay certain compensation. I think in the Total case, it was 5.6 million euros, and in the US case, it was between 30 and $60 million. But the US case, the figure has never come out openly, but that's what people assume it to be. But it was a lot of money. And those were being paid out at that time in that kind of a context. Now, you may think that that's small beer or small change for large corporation, but in terms of the value of time of senior executives that is spent to monitor the case, and think of how much they are earning, and then pro rata try to work out a calculation of how much management time has been spent, then it's a very, very expensive proposition. So even bottom line oriented companies should think very carefully before going for the cheaper alternative. That's all. I mean, I've been in closed door setting with one of the companies. I can't say the name because it was a closed door setting, but in one of the companies where the CEO, former CEO, he has retired from that company, said that he was toward the end of his career, he was spending 1/3 of his time on these kinds of cases. Now, think of how much he earned and take 1/3 of that and to add that to the cost of whatever compensation that was ultimately paid out. So I think it's true that, yes, you are complying with the local law, but that doesn't really take you very far. There are other hidden costs which you are not acknowledging in this kind of a contract, besides the reputational damage. And so let's not even go down there. I mean, you can, again, talk about name and shame. You can name and shame Coca-Cola and any company that has a high street or main street presence. How do you do that with Brown and Root or Halliburton or Schlumberger? I mean, I'm not saying that these companies are guilty of anything, but if these are the companies that are involved, there is no gas station where you can go and pick it. So there are those kinds of issues that become crucial too. Now, and this anonymous question is a really good one: how to evaluate human rights risks caused by the businesses that drop out of the Russian population. And this applies everywhere. When you divest, what are the consequences? And I think I'm not saying that it's a good or bad decision, because that's for the company to make, but they must look at the impact on the existing staff, supply chain, and the ability of the people to continue working. See if the new acquirer of the business is going to carry on operating in a way that respects rights. It may not always happen, but at least to do some due diligence in that regard. If possible, this is a report that we are writing in which we have said that if you do have a philanthropic program which is not an onerous burden, to continue doing that. So suppose, as an example, if McDonald's is supporting schools in a district outside Moscow, it's closing the restaurant, but if the money is bearable, it should continue those quote unquote philanthropic programs, because nobody shuts the door hard, right? You shut them because in the hope that someday situation will change, because we all want Russia to be a more democratic country, right? Someday the door will be open and someone will walk in again. And at that time, there'll be all the people who are not guilty. They are not so-called quote unquote Hitler's willing executioners. You use that phrase from the Second World War, the book that was written by Gola Hagen. I'm not going there, but they are not necessarily fans of Putin. And if that's where we are, then I think we need to make sure that that constituency is not felt. I know it's a terrible time, and when you leave, those constituencies are going to feel let down and hurt by that. But it's a risk that you have to take if you want to avoid exactly what Shad, you were saying earlier, contributing to and benefiting from, and not just financially, but contributing to an abuse and benefiting from an abuse. Thanks.
Thanks, Celia. I think those were some really important points. I think when we think, we talked about this a little bit in the first events as well, this need to really take account of who you're impacting by exiting, that responsible exit issue, because it is a really complex one. But simply because it's complex doesn't mean that you can avoid having that conversation about how do we take care of those people who will lose their jobs. How do we take care of the people who are dependent on the social programs that some of these companies support in their local activities? we have a question from Emma Baldy, who also did our program and also finished last year and is also out in the world doing good things around business and human rights. And her question is for Avery. This is gonna be our last question because I then want to bring Elena Uvarova into the conversation to talk about her work on essential services, and then we'll wrap up, hopefully, ideally on time. But so Emma has a question for Avery, which is from a post-conflict perspective, what are the best practices and or lessons learned from Cal and CLASP could share with regard to bringing corporate actors within the scope of TJ processes and business and human rights more generally into TJ processes and mechanisms?
Yeah, that's a great question. I think what immediately comes to mind is the Colombian transitional justice system, which is, of course, in operation right now with the Truth Commission and the Special Jurisdiction for Peace. The Special Jurisdiction for Peace only has a voluntary jurisdiction over corporate actors. So that means that companies and economic actors generally, so individual business people, have to agree voluntarily, submit themselves to jurisdiction, which is obviously a large hindrance for the Special Jurisdiction for Peace there. But I think the tribunal is really showing some promising innovations in terms of trying to highlight the role of corporations in conflict, including by looking at not only combatants in some of their investigations that they're opening. So one thing that comes to mind is thinking about a possible sort of like macro case that the Special Jurisdiction for Peace is thinking about opening into the Gran Magdalena region in Colombia, where they are looking at the role of third-party actors, which include corporations and combatants, as well as government actors in that region. And so that's a way that at least we're trying to highlight to the tribunal the role of multinational corporations. So I think in terms of best practices, they're yet to be seen. I think there's some innovations that are happening in Colombia. I guess one other thing that I'd mention briefly is that I think the sharing of information between transitional justice mechanisms and ordinary justice mechanisms is super important. So if there's something that can't be done in the transitional justice context, then seeing if an ordinary justice prosecutor or a civil lawyer could do something there. So I think it remains to be seen, but I think there's some interesting innovations coming out of the Colombian context.
Thanks, Avery. I would echo all of that as well. Emma is very familiar with that. She helped use she used portions of the Colombian context in her dissertation last year, which she wrote on reparations by businesses for their participation in armed conflict. I'm very proud of her dissertation, by the way. I'm going to stop mother henning that for a second. And Elena, I'm going to give you permission to talk and bring you into this conversation to ask you to tell us a little bit about your work on essential services.
Yeah, I will be briefly, and actually thank you to all speakers. I took a lot of good thoughts about other conflict areas, and I should say that in Ukraine companies are operating in three difficult and environment with high human rights risks. We have 20% of Ukrainian territory which is occupied now, and we have territories with active military actions, and we have territories which is quite safe at the moment, and companies which are providers of essential services and goods, of course, they are operating in this complicated environment, and when we are talking about essentiality of some services and goods, we should remember about context specific of essentiality, and some services and goods which are not considered as essential in peacetime could become essential in this time, and I totally agree that bank services, telecommunication, access to internet, water supply, medicine supply, food supply are essential in a situation of military actions and in occupied territories and in the rest of territories of Ukraine, in particular because of 8 million of internally displaced persons, and of course it's also a huge challenge for normal operating of businesses in the rest of territories. So actually, my point is that human rights due diligence should take into consideration essentiality of some services and goods in this complicated environment, and also the Ukrainian context has some specific because some of these services are provided by state-owned and municipality-owned companies, and some of these services are provided exclusively by private companies, and business conduct of these types of companies are very different, and the type of corporate thinking, I would say, types are very different, and Ukrainian case could show these differences between different types of companies and how these differences could impact on providing of essential services in a complicated environment. And so, yeah, and also I would like to emphasize that I totally agree about the risks of labor rights, and we really see in Ukraine now the high risks for labor rights in times of war, because the key priority for state now to push economy in some way, and human rights was not key priority for economy in peacetime, and now we see that situation, of course, even worse, and at the moment we have new legislation that makes position of employees much more worse than it was before, and yeah, labor rights are under risk in Ukraine today. It's just my comment to conversation. And the very last comment, that I think that essential services show very clear this importance that you emphasized, mentioned today, importance of not just duty to respect, but duty to protect and fulfill. Thank you for the opportunity to comment.
Thanks, Elena. Before you mute yourself, I want to give you an opportunity to also name the funders who have been funding your research in this area, because I know there's at least one out there, and I think that they deserve credit.
Yes, we are doing this research in cooperation with Danish Institute for Human Rights, and I also hope that our colleagues from Global Association will comment this research and contribute by these comments to this research. So I would be thankful very much for these comments when we will have the first draft.
Thanks, Elena, and thanks for joining us. So Elena's been doing that work from the very early days of this conflict. She's been looking at these issues of business and human rights in Ukraine. She's been at the forefront of the conversations, and at this particular conversation on essential services. And I have to say that context, Avery mentioned that the Colombian context is sort of the standard right now by which we're seeing best practices, and I absolutely agree with that. And I remember that when Colombia, I'm old enough now that I remember when Colombia broke into being a post-conflict society, and the sort of enthusiasm within, at the time, the very small number of us working on corporate accountability and transitional justice, the enthusiasm over having a new state set a standard that all the other states had sort of pointed to for a very long time, but hadn't actually been able to implement. And I'm finding that same, we obviously none of us want to be going through this period of time or having to witness what we're witnessing in Ukraine. But there's something in the midst of that darkness that is a point of hope that comes from seeing societies take us further in our approach to these issues than those that came before them, building on lessons from the past. And within the context of Ukraine, I've seen that a lot. I've mentioned already that they're doing on the ground investigations into war crimes in the midst of the armed conflict, that they're taking the provision of justice seriously and ensuring that those who are accused have access to strong legal representation, despite the gravity or because of the gravity of the crimes, that representation is commensurate with the gravity of the crimes and the potential for sanctions that they're facing. And within the context of business and human rights, this conversation around essential services is something that we've been having in very low level sort of recognition that it exists and we need to tackle it. And seeing the Ukrainian business and human rights community, seeing the partnership between Olena and the Danish Institute emerge from this conflict, it is not the impetus that we would want. It is not how we would want to get there. But I have to say that watching that emerge has given me hope in the period of time in which sometimes it just feels a little hopeless. So Olena, you are a credit to our field. That I've long thought that, but you have proven it time and time again. And so thank you for your work on that. We're going to bring this to a close. Before we do, I have to thank a few people. Longdi Yu is our current frontrunner on our events and communication. So our current student worker who put this together and has made sure that I don't forget to respond to emails for too long, right? Like definitely longer than they should, but she has made sure that this event happens, and she is the reason that it happens. So Longdi, thank you so much. I also want to take the opportunity to acknowledge our other student workers whose contracts have recently terminated. I wish that I could keep them forever. You already saw how much I just adore Jenny and Emma, and I feel the same way about Gabriella. This is going to be awful. I'm going to butcher all of their names, even though I absolutely adore and love them. So Gabriela Almeida, Noor Jaijin, Juan Morales, and Regina Lopez, as well as Longdi Yu. They are brilliant. They are dedicated. They are passionate about business and human rights. They always come to me with the most interesting questions, and they have pushed BHR further this year with their commitment. And I am eternally grateful, not just because this year I was left on my own. Normally I have a co-director with Anelia Best who is on maternity leave, and she keeps me on track. And then they left me to my own devices this year, and I had to rely on 5 students to make sure that I knew how to tie my own shoes at times. So thank you guys for that. You give me hope about the future as well. And thank you to everybody else for coming today. This is really a really important event, and I am really grateful. I'm grateful to our 3 speakers. As I said, I've been fans of all of them, some of them for years. Celia, I won't tell you how long I've stalked you on Twitter and in the business and human rights community. But I will say that neither of those 2002 reports were new to me. And I first wrote about business and human rights in 2004, and I know that I used those reports. So I may or may not have been, fangirling over Celia for close to, oh my God, that's 20 years. All right, I'm gonna have a midlife crisis here. So I'm gonna conclude with, again, thank you so much, Avery, Celia, and Shahad. You're brilliant, and I'm glad that everyone else got to learn from you alongside me today. So thank you so much. Bye, everyone.
Bye, thank you.
Thanks very much.
Thank you so
Bye-bye,
much.
everyone. Lovely to talk to all of you. Thank you. Bye-bye.
Bye.